Let's see how we're doing. I hope everybody is having a good day. Let's see. This live stream, I'm just kind of doing on a random Saturday. I've had every intention of doing this multiple times this week. And my sister-in-law was in town, who we loved having for 2 weeks. And we did all the things. Hawaii. We went to Pearl Harbor. We went to the temple here. I cannot remember the name of it. But anywho, we went and did all the things. Pearl Harbor, the temple. We went to Waikiki Beach. I took her to Lanakai yesterday, which has been voted one of the most beautiful beaches in the world. And it is. And so we did that. We have eaten ourselves through all the things: Korean, Chinese, Japanese, lots of all the things. So yeah, it's been a great 2 weeks with her. She is now back home in Asheville, North Carolina. I'm still drinking my coffee from earlier this morning. It is cold. It is currently, I think, 7:44 back home, and it is 9:41 a.m. here. So I am going to catch us up on the lawsuit. Hi, folks that are joining. You can always chat with me in the comments on YouTube, but I am going to catch us up on all things related to the lawsuit. Again, the lawsuit are defendants, members, and neighbors within the Fairfield Harbour community versus the plaintiffs, which is the Fairfield Harbour Property Association, and then a handful of current and past board members. And so with that, we have not really heard a whole lot related to the lawsuit since December. In December, I did an update with the second amended complaint that was filed and went through all 125 pages of that, including all exhibits. It was really knowledgeable. I also did a TLDR, which, for those that asked, too long, didn't read, is what the TLDR acronym stands for. So I get it. A multi-hour long live stream is not for everybody. I personally love long form content, but not for everybody. Totally understand. A couple days later, I did a summary of what we learned in that Second Amendment complaint. Have been crickets about the lawsuit in January. That is not to say, God bless, I'm going to start a live stream and the dogs are going to start barking. That is not to say that a lot has not happened. There have been 19 options for things that have been added to the docket. One of the things that I am going to do, let me just remove some of these things from my slides. I am going to share. I have said before that not everything that I get access to, people are like, how do you find this? It is publicly available for everyone. So I am going to walk us through, how do I even get to the Craven County Court docket? How do I find this lawsuit so that I can stay up to date myself without Emily having to gab about it? Okay, so allow me, if you will, to take us through. Let me share my screen. I'm just going to share this tab. So we're just going to start fresh. Okay. So if I just Google search Craven County Court docket, that's all I do. And then I go to Craven County. Okay. This is the North Carolina Judicial Branch, Craven County. It shows you a little picture of where we are. I scroll down just a little bit and I want to go to the Craven County Courthouse. When I click there, gives you some information about our courthouse. And I'm going to say, find online services. There are multiple ways to get here. This is just what Emily has up here as her how-to. I'm going to get started on the portal, and I'm going to do a smart search because nobody likes a dumb search. Okay. So you can see here, I obviously search for this a lot. Our court docket for this lawsuit is 25 C as in Charlie, V as in Victory, 001224-240. That is the case number for this lawsuit. Okay. I'm going to just say it again. I do keep it on my screen as like just in a little notes thing. That's the only thing in there is this number, just so I have it handy and I copy paste. 25 Charlie Victory 001224-240. Then you click I am not a robot and you click submit. And you will see this. It has Daniel Ritter here. He's top line billed. When I show you this, if you click on the case number, there's a lot of information here, okay? You see the case summary, and you will see all of the defendants. It is not just Daniel Ritter. It is not just one or two neighbors. It is not just 5 people that are causing a lot of noise. This is a long list of people that live in and care about Fairfield Harbour as a community. And so this is all of the defendants. These are the plaintiffs down here filed against. You'll see Fairfield Harbour Property Association, Les Pendleton, Robert Brody, Lawrence Basin or Larry Basin, and then Susan Debra Harris. Those of us on Facebook know her as Debbie Duckett Harris, I think is how, or Debbie Harris Duckett. I don't remember how exactly it goes. Sorry if you're hearing background noise behind me. Okay, so that's this case information. You can go by the file dates here. Lots of causes of action. I'm not going to go through all this. You can do this on your own. This is, and I have no explanation. I am not a lawyer. I do not work for a courthouse. I can read words on a page. That is as sophisticated as I get. You will see here that this court case assignment was assigned to the Craven County Superior Court February 10th of 2025. So it has been a year plus now since this case has been assigned to a court, and we are in Craven County Superior Court. Okay. You will see some other party information here in the lawyer that has been retained to support those defendants. And then you will see the causes of action, declaratory judgment, preliminary injunction. There's been a lot of, again, action here. Let me go back here to causes of action, case events. This is where I saw how much has happened. So you'll see, I mean, there's so much information here. All of the notice of hearing, scheduling order, case management order, secure leave request, all of these things happened in 2025. We did in December. Again, you've got a bunch of status conferences and things like that that happened throughout December. Then you will see that we have the notice plaintiff's motion to amend the complaint. So that's the second amended complaint, happened December 17th. Then there was an order on the defendant's motion to attend that or amend that case management order. We had a defendant's motion for an extension of time to respond to the plaintiff's motion. Again, I have downloaded all of these files. Then we start getting into January, where we start getting letters in. We get a letter to the judge, Judge Brown, from Debra Rothengast. So it started, I think the first letter that was received was from Chris Barajas. So we are going to go through all of these things. This is going to be a long one. Feel free to grab 2 drinks. And I will say that this is going to be a little clunky. I can only upload 6 PDFs at one time to go through. So once we exhaust the first 6, I will remove those and I will add the next. Okay, so I'm keeping a piece of paper here with where I am in my numbering so that I know, because when you download these things, they're going to download to your computer as the case number _1, _2, _3. They are not listed as what the actual thing is. So we're just going to go in order through all of the letters that the judge has received. Through Friday, the judge continued to receive letters through that were uploaded through Friday, February 27th. So that is where today is the last day of February. This is not leap year. So for those leap year babies, whether you celebrate on the 28th or the 1st, happy birthday. I hope you have a wonderful week. We just had Lee Fawcett. His birthday was just a couple days ago. So anyway, lots of February birthdays, but I'm going to end the month here. And then we'll know moving forward what is new. Okay. So we're just going to go through all of these things. I am going to, but that's how you get to the docket. And now I'm going to pull up. You didn't see any of that, did you? No, you didn't. Let me add this. What am I removing? Remove. We're going to try this again. Add to the stage. Apologies. See, it takes me to a different screen and I don't see what you're seeing until I get back and I'm like, that was wrong. We're going to start over really quickly for those that just need the refresher. We are going to go to a brand new Google page. Okay. We are going to type in from here, Craven County Court Docket. Looks like this. Click on Craven County. Scroll down and click on Craven County Courthouse. Scroll down and click on Find Online Services. Get started on the portal. Smart search, not dumb search. Again, our record number here is 25 Charlie Victory CV 001224-240. You are not a robot and you have to click that button and you're going to hit submit. It is going to bring up our case number and you are going to click that hyperlink and it is going to bring you, let me remove this and go down here. Now I'm going to share a different screen. Stop screen share. Share screen. We will go to this page. This is what it brings up. Case summary. Case information. I am not going to go back through this. All right. Party information. Causes of action. These are all of the individual causes of action that have happened since March 12th with the first declaratory judgment. Okay. These go all the way through to the most recent preliminary injunction. Okay. In December. Then we have all of the case events. So the causes of action go in order from most recent, or I'm sorry, furthest back in time to most current. So we're going all the way back to March. And then we come forward with all of the actions in order. Case events starts with most current and goes back in time. So they're opposite. Okay. So we are going to be covering everything on this page from the end of December when we did the last second amended complaint to today, February 28th. Okay. So having said that, let's go through. I'm going to remove this from the stage. I'm going to be smart about it this time. I'm going to just take. So when the lawyers for this suit are going to take leave, the court needs to know about it, right? So that we don't schedule anything that requires an in-court appearance during that time. All right, so we have designation of secure leave period. So you will see on this page that Kevin Chignell, sorry, I butchered that. Okay, try this again. I got to be able to see, right? Hereby files this designation of secure leave period pursuant to Rule 26 of the General Rules of Practice. We're not going to read through all of that, but he will be out requests the period of leave Monday, June 8th through Tuesday, June 23rd. So he will, no other secure leave has been designated for calendar year 2026 by this person, and they certified that this leave is not designed or designated for the purpose of delaying or interfering with the timely disposition of any proceeding. I hereby state that no action in which I have entered an appearance has been scheduled, peremptorily set or noticed for trial, hearing, disposition, or other proceeding during the designated secure leave period. I state I have taken adequate measures to protect the interests of my clients during these requested periods of leave. Respectfully signed, this lawyer. Okay, so we'll remove this. Number 2. Oh, wait, I have to go. These got out of order. So the defendants, the folks that have the lawsuit, okay, the defendants requested an extension of time to respond to the plaintiff's motion to amend the complaint. Pursuant to Rule 6B, I'm just looking for the date it was filed. So this was filed December 29th, so before the end of 2025. Pursuant to the Rule 6B of the North Carolina Rules of Civil Procedure and Business Court Rules 4.1, defendants, through their undersigned counsel, hereby move for an order extending the time which to serve a response to plaintiff's motion to amend complaint. In support of the motion, defendants submit the following. Plaintiffs filed the motion to amend the complaint in this action on December 17, 2025. The time for defendants to serve a response to the motion to amend the complaint has not yet expired. Counsel for defendants needs additional time to fully investigate this matter and prepare a proper response to the motion to amend the complaint. Defendants make this motion for good cause and not for the purposes of unnecessary delay. Because time is money, right? So when we move things out and we request more time, we can expect it's going to cost us. Pursuant to the BCR 7.3, counsel for the defendants has consulted with counsel for the plaintiffs, who does not object. I think I have the plaintiffs and defendants mixed up, but whatever. We know what we're talking about. Defendants has consulted with counsel for the plaintiffs, who does not object to the extension of time sought by this motion. So there was no objection from the opposite side. Wherefore, the defendants respectfully request an extension of time from January 6th and including January 20th, 2026 to file a response to the plaintiff's motion this 29th day of December, 2025. So there was a request to extend the response period from the 6th to January 20th. So adding about 2 weeks of time there, right? And then there's an order granting that extension of time. Let's just read number 1. This matter is brought before the court. The motion for extension of time to the plaintiff's motion to amend the complaint. Defendants, through the motion, request an extension of time, including January 20th, to respond to the plaintiff's motion to amend the complaint for the purpose of fully investigating this matter and preparing a proper response to the plaintiff's motion to amend complaint. Plaintiffs do not object to the extension of time sought by this motion. It appears to the court that good cause exists to grant the motion. The motion is not made for the purpose of delay, and parties consent to the request extension. Wherefore, the court, in exercise of its discretion, hereby grants the motion. So we have now until January 20th to respond, which is past, right? So there has been a response. Okay, let's remove this. It's 1, 2. We did that one. This is 4. Okay, secured lead motion. This is from Hope Carmichael. This is the lawyer for the POA. So she has 2 weeks of designated secure dates. So May 4th through the 16th, and then again, August 31st through 9/6. So she's just making the court aware of when she will be out of the office. And this is 5. Okay. So 1, 2, 3, 4, 5. Nope. 1, 2, 3, 4. Hold on. Let me add 5. I don't remember what 5 was. Open. but we're not going to lose it, is what we're not going to do. It gets kind of hard after you get 19 attachments, okay? This is Chris's letter, okay? So this is our first letter that the judge received. It was filed January the 9th of 2026. This is going to get real small, so I'm going to make my screen bigger. My name is Chris Barajas, and I am a 4-year resident of Fairfield Harbour and a retired master investigator from the Riverside County Sheriff's Department, California. Throughout my 27 plus years of service, I've investigated sexual assault, child abuse, murder investigations, and worked diligently within the confines of the law. Recently, I resigned as vice president of the Fairfield Harbour Property Owners Association due to a betrayal and duplicity. Director Don Moore and I were elected to the board of directors on June 26, 2024. We were present at the June 28, 2024 board meeting where the bylaw change occurred, which ultimately prompted the lawsuit over which you currently reside. On that day, Hope Carmichael provided us partial and incomplete counsel on our duties and responsibilities. She did not inform us the meeting was called improperly violating the FHPOA bylaws. She also did not mention that we had the right to leave or participate in that meeting. I noted the lackadaisical application of the rules, North Carolina general statutes, bylaws, policies, Robert's Rules of Order, etc., upon my election to the board of directors at the annual meeting and after the election results were announced. I was then handed an announcement letter for a called meeting scheduled for the following morning at 9 a.m., thus violating the FHPOA bylaws. And there is a footnote 1. FHPOA bylaws Article 5 powers Section 5 meeting of the Board of Directors subsection B states special meetings including electronic meetings of the board may be called by a majority of the board and shall be held at a location at such location, date, and time as the called notice for meeting shall designate. Notice of a special meeting of the board may be given by the secretary in writing or orally at least 24 hours prior to the time of said meeting, or notice thereof must be waived by the directors in writing, as stated. Okay, that's second. All right, I informed President Gail Albertini, the FHPOA bylaws required 24 hours notice before a called meeting. A correction was quickly sent out and the meeting was set for Friday, June 28, 2024 at 1 p.m. The June 28th meeting could or should not have occurred because Gail did not have the sole authority to call a meeting. No majority of the board of directors agreed to the meeting, and should a director request a meeting of the board of directors, a majority of directs must agree to it in writing or orally. That agreement should be memorialized in the meeting minutes. At that time, I was unfamiliar with these rules and did not call attention to them. Being new to the board of directors, I was unwittingly participated in that meeting. The meeting began with Director Les Pendleton requesting an amendment to the agenda. He wanted to change the FHPOA bylaws as it pertained to the voting threshold for removing a director. Hope heard that request and obliged conversation about it and his intent on the percentage change. She did not mention nor inform any director the FHPOA bylaws and NCGS 55A, she did not mention nor inform any director that the FHPOA bylaws and North Carolina General Statutes 55A are strict on how and when a bylaws change can occur. She listened to his request, noted it, and suggested she would research it while the meeting's agenda progressed. At the time of this meeting, I was somewhat familiar with the FHPOA bylaws and the vaguely knowledgeable of the protocols for how a board of directors meeting was conducted. It was that naivete that caused me to miss the adherence to the policies and the protocols that were established in the FHPOA bylaws, North Carolina General Statutes 47F, 55A, and Robert's Rules of Order. Interestingly, Hope contradicted the counsel she provided Don and I in a letter she sent Wes Collins on October 8, 2024. The counsel she provided us differed from what was stated in the letter. We were not provided all of the information pertaining to our responsibilities and obligations, whereas directors, including the advice that we could have stopped the meeting because it was called improperly and violated North Carolina General Statutes 55A 10-20 or the FHPOA bylaws. Hope Carmichael highlighted this information in her letter, which stated, "The association does not dispute that the amendment in question was raised by motion at the board's June 28, 2024 meeting. The failure to provide notice of the potential amendment does not, however, invalidate the amendment. A basic tenet of corporate law is that a director's attendance at or participation in a meeting waives any required notice to him of the meeting unless the director at the beginning of the meeting or promptly upon his arrival objects to holding the meeting or transacting business at the meeting and does not thereafter vote for or assent to action taken at the meeting." North Carolina General Statute 55A-8-23. No objection based on lack of notice was made by any director at the meeting, and all 7 members of the board remained at and participated in the meeting, all as reflected by the minutes of the June 28th meeting. Accordingly, any notice requirement was waived. I have found no statutory or common law support for your bald assertion that the failure to meet notice requirements of North Carolina General Statute 55A-10-20 renders the amendment void ab initio. Void from the beginning. Look at me learning stuff I can recall. A statement as such is troublesome because it reflects a willingness to slant or taint information for your personal benefit. Had she counseled me on what the law states, I would have exercised my right to the fullest, yet her biased delivery of information suggested her agenda was different than the wholehearted protection of the corporation, as her responsibility and representation requires. Dawn and I objected to the bylaw change as it was a blatant act of self-serving preservation. The bylaws exercised removal of a director is one that was only attempted one other time in the existence of Fairfield Harbour. It is not a bylaw that is abused or misused. It is a mechanism, short of legal action, afforded to the residents to voice their disdain for a board of director that is, in their collective opinion, not acting in the best interest of the membership. The increased change of percentage is a hamstring in the community's voice. In response to an action the board of directors chooses to conduct, the previous threshold was hard to obtain, thus why it's only been attempted one other time. Increasing it to a supermajority makes recourse against the board of directors nearly impossible. Frankly, I did not hear any argument in that board of director meeting to sway me to support increasing the percentage threshold. There aren't many mechanisms afforded to residents in HOA, POA environments to allow for a checks and balances protocol. The argument I heard started out as a conveyance of a rumor about another recall petition pertaining to 2 unnamed directors. Be it that the board of directors is a volunteer position and is heavily scrutinized by the residents it governs, increasing the percentage threshold on a whim is a self-serving and reeks of promoting a personal agenda regardless of cost. Hold one second. I'm going to get my computer to stop doing what it's doing, moving me in and out. Okay. Hold, please. I think I moved the page. Yes. Increasing it to a supermajority makes recourse against the board of directors nearly impossible. Frankly, I did not hear any argument in that board of director meeting to sway me to support increasing the percentage threshold. There aren't many mechanisms afforded to residents in HOA, POA environments to allow for a checks and balances protocol. This argument I heard started out as a conveyance of a rumor about another recall petition pertaining to 2 unnamed directors. Be it that the board of directors is a volunteer position and is heavily scrutinized by the residents it governs, increasing the percentage threshold on a whim is self-serving and reeks of promoting a personal agenda regardless of cost. However, several times in our counseling session, Hope informed us that it was her job to keep the organization protected from lawsuits. The June 28th meeting was filled with animosity and frustration. Neither Dawn or I agreed to what occurred, yet we were the minority. 2 of the majority, 5, were unhappy with our unwillingness to progress their agenda. The motion Les presented was simplistic, yet it passed with a 5-2 majority vote. Another footnote 3. Director Pendleton made a motion to amend the bylaws stating that any vote for removal of any member from the FHPOA board, including current members, will require 67% of the POA members of the community. So that's 67% of everybody, which we've never even had. Curious if we've ever had 67% of the entire community vote. No motion vote was taken on granting Hope approval to author a resolution for the bylaw change, although it is noted in the minutes. Oh, so there was no motion taken to give Hope approval to author the resolution, although it was stated in the minutes. So we're saying that the minutes include something that did not happen in the meeting. I'm going to need something stronger than this cold coffee. A July 3rd email was sent out for approval on the June 28th meeting minutes. That email request was not unanimous, thus requiring an in-person meeting. 5. Footnote 5. Am I missing a footnote? Oh, wait. Footnote 4 on the whole minute situation. Attorney Carmichael will send Secretary Miller the exact wording needed for the amendment. Okay, so she had already said she would send them the exact wording for the amendment in the meeting minutes, though no one in the meeting requested her to provide that language. And that means that she's spending time that she's going to bill us for, right? Again, time is money. She's going to spend time drafting language for a bylaws amendment that she was not asked to do, and the bylaws, I can't. We're first letter. All right, 5, footnote 5. Per the General Assembly of North Carolina Session 2021, Session Law 21-162, House Bill 320. That's footnote 5. I'm trying to find it up here. I see 4. I don't know. It requires that general statute requires an in-person meeting when there's not a unanimous vote on the approval of the meeting minutes. Again, the rules were not adhered to, and the July 28th meeting minutes were published anyway. On July 11th, 2024, Hope's rendition of the bylaw change resolution was published. The verbiage of the resolution is different than the motion presented. The bylaw change is very different than what's previously published, and verbiage is included in the resolution that was not discussed or voted upon during the board meeting. Additionally, the resolution was published without review or vote of acceptance by the board of directors. The discrepancy in the resolution from the motion also violates Robert Rules of Order 434, putting a question where a motion must be exactly stated. Then on July 24th, if you're watching, and I see folks out there, hello. I mean, just go ahead and share it with your neighbors and friends, because I can see myself losing it here in a minute, okay? It's going to be long. Then on July 24th, another email titled Emergency Vote Needed. So there was an email sent out, Emergency Vote Needed, was sent requesting approval of modifications made by Hope Carmichael to the June 28th meeting minutes. Hope added verbiage to the minutes. Why is our lawyer adding verbiage to meeting minutes when we did not ask her? Again, she is wasting our time. specifically related to the Harbour Club construction loan. So now we're pulling in the Harbour Club construction loan into this very tricky already situation about the changes to the bylaws for the supermajority vote. Okay, so stick with us. Stay here. She asked to add verbiage to the minutes specifically related to the Harbour Club construction loan at the request from Truist Bank. Again, a request for a unanimous approval was sought, and Dawn and I opposed the changes. A majority of the board of directors approved the request, even after my request to amend what was previously adopted, citing Robert Rules of Order 35-1. Also, in my response email, the directors were informed this is more of the same problem that we just discussed on Tuesday. We have a procedure to follow, and making it up as we go is not the proper way to operate. Additionally, the community manager, that's Jennifer Judegas. I always say her name wrong. I'm sorry, Jennifer. I will maybe one day get it right. The community manager replaced the approved June 28th meeting minutes with the amended version. In essence, rewriting history and publishing a different rendition. There is no record of the modification or accounting of why it occurred. Just a published version of the June 28th minutes that is modified to fit the needs of the few. Throughout my tenure on the board of directors, I noticed a prevalent haphazard culture regarding the rules that is deeply rooted. If a rule conforms to a certain desire, want, or need, it's followed. Otherwise, it's subjective. This behavior is very contrary to the environment I worked. Throughout my time on the board of directors, I addressed this issue with following the rules, and I was ostracized for it. In early April 2025, a called meeting of the board of directors was challenged by Don. He cited the bylaw violation, and it was ignored because President Pendleton could not reach Hope via telephone for guidance. In May 2025, another called meeting of the board of directors occurred. This time, I challenged it by citing the same bylaw violation. Les again called and sought guidance from Hope. She affirmed my objection, informing him that the bylaws violation and how to proceed. That meeting was adjourned, but not before a majority of the board of directors agreed to a called meeting the following day. Ironically, the information related to the improperly called meeting and its cancellation was not included in the meeting minutes for properly called meeting. When Dawn and I campaigned for directorship in 2024, we did it as a team. We were two independent residents who came together over similar ideologies and viewpoints on repairing our community. We ran on a platform of inclusiveness and transparency. Our alignment and outlook quickly developed a strong support base in the community. We spoke about the community's future often and strategized, developed, and prepared plans to boost resident morale and address predominant issues. We also spoke about the 2025 campaign season and how adding two favorable candidates would tip the majority in our favor and the plans would be implemented. Throughout 2024 and 2025 year on the board of directors, we were scrutinized for our peer directors and shunned by the FHPOA attorney. Regardless, we stayed true to the vision of the future and focused on upcoming election cycle. We continued discussions on how to change the trajectory of the community, identifying many of the core issues that fostered discontent with the residents and worked on a plan to correct those issues. We worked side by side on idea after idea, knowing our present board of director peers were not interested in any changes that contradicted the efforts and progress implemented by the ousted POA president that started the division within the community. Between July 2024 and April 2025, there were 5 changes in the boardroom. 1 director died, 2 duly elected directors resigned, and 5 different people were elected by the board of director to the director's seat. One of those seats experienced a 3-person turnover. With each seat opening, the controlling majority of the board of directors solely chosen replacements that support their vision of the community. Director Moore and I opposed each of those appointments, knowing the agenda moving forward was something the majority of the membership did not want. Regardless of the bylaw change in June 2024, the community rallied and initiated a second recall vote, which fell short of the newly implemented bylaw change of that 67% of the community at whole. This action represented the dedication and frustration of the community, from the community. We were pissed, being real frank, and how they feel about the direction forward without the board of director allowing the membership to vote on it. Director Moore and I noted this bold action. We worked on different strategies and reviewed North Carolina General Statutes law to figure out different ways to correct this matter. A great deal of time and effort was spent working on ways to properly heal and fix this fractured community. We felt that change would occur if the community voted 2 candidates into the board of directors that supported theirs and our ideology. This would provide a 4-3 majority in our favor, which would provide the shift necessary for a community-first mindset in the board of directors. Throughout the duration of my directorship, I was bold in my objections and bore the brunt of retort and frustration from the other board of director members, to the point where I was labeled an obstructionist by many of the members of the board of directors. To some, boldness is challenging and difficult to manage. To others, it's a representation of the atmosphere of the community being shared. Director Moore supported my efforts and often encouraged it, knowing I was not shaken by their disdain for my boldness. Throughout the past 16 years, I felt Director Moore and I were of the same plane, focused on the same objectives. Prior to the election results, candidates Wayne Anderson, Lee Fawcett, Director Moore, and myself met often and discussed plans to move the board forward, the community forward. This was all contingent on them winning the election, of course. We all agreed that addressing the 67% rule and averting it back to its original verbiage would start the healing process and effectively end the lawsuit. That's all it would have taken. The plans we developed were sound, reasonable, and lawful and efficient, and at the top of the activity list. Lee and Wayne won their 2025 election, and it appeared to be a start of a new direction for Fairfield Harbour. A properly called meeting occurred the following Friday, June 27, 2025, in which I was nominated and supported by Director Moore being elected as president. He, in turn, nominated and supported my election to vice president. Chris nominated and was supported by Director Moore in being elected president, and then Chris was vice president. Then, as part of our plan, a series of meetings were to be called with an emphasis on strategically addressing the issues of the community. Those meetings did not happen. Instead, Director Moore reclused himself from the rest of us and ceased communication. Several attempts to contact him were made, and he was unresponsive in returning the calls. This behavior was concerning because it was uncharacteristic of the relationship Don and I had throughout our campaign and directorship. We communicated often, discussing action intended or anticipated. Our lines of communication were open, flowing, and collaborative. Then, after his appointment to POA president, they stopped without explanation. Knowing the next board of director meeting was scheduled for July 23rd, 2025, Director Anderson and I worked on motions and actions to present at that meeting. A motion was developed to address the inconsistencies with the delivery of the bylaw change request and how to address, nullify, and correct it. The 4 of us agreed to this cleverly crafted motion and supported it. By approving this motion, the bylaws get reverted, effectively ending the lawsuit and promote a much needed healing. In the days leading up to the meeting, I was optimistic about the change on the horizon. Wayne was so encouraged by the future, he returned from his Western North Carolina vacation to attend the July 23rd board meeting and vote on this motion. He also created other motions pertinent to issues that needed addressing. Furthermore, he informed Don of his adamancy on presenting his motions at that meeting. Prior to the meeting, the agenda was provided, and I noted Wayne and I were listed at the bottom of the lengthy agenda. Director Anderson was upset about his location on the agenda and sent President Moore an email requesting a shuffling of the agenda to allow Wayne's motions to be heard, since he was only present in town for that day and returning to his vacation. That request was unaddressed. A large crowd attended that meeting, anticipating the motions Wayne and I prepared. The meeting started at 9 a.m. and spanned for almost 3 hours. 2 of those hours were consumed by guest speakers discussing non-pertinent issues. Motions from the other 5 board members were heard and addressed. When it was time for Wayne's and my topics to be discussed, the meeting was adjourned, citing a lunch break, and the motions we prepared would be added to the August 2025 board meeting. Dawn, having the authority to control the board meeting, did not object to this announcement, nor did he make any concessions to modify the meeting agenda to allow for pressing matters to be presented up front. Wayne and I were deeply offended and very angry that our matters were not taken seriously. The outward betrayal of trust was overwhelming, and we opted not to attend the afternoon session. The afternoon portion of the board meeting was closed to the public due to more guest speakers and executive session matters that needed addressing. Don's actions at the open board meeting announced his disinterest in addressing the matters pertinent to Fairfield Harbour. He consciously chose to ignore the motions Wayne and I drafted, knowing a majority vote of the board of directors would change the course of the community and begin the healing process immediately. His actions betrayed our friendship, our working relationship, and the community's trust in his intentions about the legal issues within Fairfield Harbour. Wayne attempted to resume his peaceful vacation in Western North Carolina, but was consumed with anger and frustration about this betrayal. His health and sleep patterns were adversely affected by his tumultuous turn of events. A few days later, I was summoned to California to sit as an investigating officer for a 2-suspect, 2-jury homicide trial. Wayne and I spoke about occurrences of July 23rd and brainstormed on how to further address the issues in our community. Wayne returned from his vacation and was scheduled to attend a closed session board meeting. He intended on presenting a motion related to bylaw repeal, and I supported it. I arranged with the court on this important community matter and was granted permission to step out of court should I need to vote on this motion. Again, Dawn did not support Wayne and provided him an opportunity to speak. Again, Dawn did not support Wayne and provide him an opportunity to speak. Thus, Wayne's motion was not presented at that meeting and ended with no resolve. Several different approaches were plotted and 2 distinct paths were identified. One addressed the poor language in the FHPOA bylaws that stated these bylaws may be amended by the affirmative vote of 5 of the 7 directors of the board. This presented the may versus shall must argument that would effectively allow a majority vote of the board of directors to change the bylaw. This too was thoughtfully discussed by Wayne, Lee, and Dawn. Initially, all 4 were on board with the idea and supported the motion. Then Dawn recanted his position and suggested he would not support that move, citing it was not strong enough argument for him to support. Further research was conducted, and Wayne discovered North Carolina General Statute 55A-8-08, removal of directors elected by members of the board, and how its applicability to the present board of directors could change the dynamics of the boardroom. Director Mike Foster, in a 3rd-time replacement for Tina McLamb's elected position when she resigned in July 2024, Tina was elected in June 2023 and resigned in July 2024. Each of these 3 following directors elected to Tina's seat were elected by a majority of the board of directors. Tina's replacement, Julie Finlayson, was replaced by Ted Wample, who was replaced by Mike Foster and still seated on the board of directors, thus making him 3 times removed from the election by membership. I called Don and discussed this strategic motion with him. He initially was supportive and suggested I present this motion at the board of directors. Then he changed his tone and suggested we need to speak with his personal attorney about this motion and he would get back to me. He encouraged me to do the same and we would discuss it later. Later never came, and Dawn has not contacted me since. In fact, I sought legal guidance on this matter and was strongly encouraged to present it. A week before August 2025 board meeting, Wayne met with his cardiologist, and it was determined that his health was failing and his time on the board of directors was short-lived as he needed to resign. He was innately familiar with the new motion and was dedicated to seeing it through. He agreed to hold off on his resignation until after votes related to North Carolina General Statutes 55A-8-08 motion occurred. The week of the August 2025 board meeting, Wayne, Lee, and I met to discuss North Carolina General Statute 55A-8-08 Subsection H, motion to subsequent actions, and we agreed on a four-part plan, which would begin the healing process for the community. In order for these actions to occur, it would require a majority vote of the board of directors, including Dawn's vote. Part 1, the 55A 808 motion to remove Director Foster. 2, as a matter of the board of director business, vote in a new director with a community-focused mindset. This would provide the seated board of director a 5 out of 7 majority. Part 3, a motion to revert the FHPOA bylaws back to their original verbiage, effectively nullifying the lawsuit. Part 4, Wayne would present his resignation letter and return to a retired living with focus on his health. Those actions were going to occur beginning at the August 2025 meeting. In order for this all to unfold, Dawn needed to support these moves. However, he was not engaged with any of us regarding anything board of directors related. Yet it was important to his understanding this was a one-time event. Yes, yet it was important to understand this was a one-time event. Once the motion was presented, it could not be addressed again for 1 year, according to Robert's Rules of Orders. The day before the Board of Directors meeting, August 25th, 2025, Wayne informed Dawn of his intentions and health issues. Dawn responded to Wayne, informing him he was not supportive of the H motion and would not vote in favor of it, essentially telling Wayne, Lee, and myself he would not progress the plans we all worked on for the healing of Fairfield Harbour. This was another shock of betrayal and duplicity. He openly supported our efforts, then refused to cooperate in those actions. Upon hearing the news, I called Dawn and briefly spoke with him. I requested he step down as president, and he refused. He was unwilling to change his position and did not provide any reason for his change of mind, knowing this was our last-ditch effort to correct the wrongs, and henceforth there would be a lame duck board of directors where nothing would be progressed and accomplished. I suggested his actions left me with the consideration of resignation. His only response was, okay, and hung up on me. This was yet another example of disloyalty and betrayal. Knowing this information, I tendered my resignation immediately. The decision to end my tenure on the board of directors was not taken lightly. This was a heartfelt journey filled with the best of intentions. My career as master investigator allowed me to speak for those who could not or would not speak for themselves. I also understand how power corrupts minds. Stepping away from this position was a heartfelt move to maintain my grace and distancing of evil in my life. I spent 28 years looking into the eyes of child molesters, killers, and deviants. The justice for those victims was highlighted in those convictions. In this environment, it became apparent to me that people who experience a little power and consumed with retaining and growing it, stepping out of that environment was necessary for my mental, spiritual, and personal health. Trust is earned, respect is given, and loyalty is demonstrated. Betrayal of any of those is to lose all three. Hopefully, and I don't see the footnote on this page, hopefully I have conveyed an understanding of how this community is hurting and some of the actions that led us to this point. Attached below is the letter that I presented to the community after my resignation. The bullet points are hot button topics the community wanted addressed. Had the plans come to fruition, many, if not all, of these topics would have been addressed appropriately, and the community would be well on its way to healing. Thank you for reading this letter, and I wish you well. And then this was his letter to the community after his resignation. After the June 2025 election results, we were hopeful that a 4-person majority would affect change and healing in our community. That was not the case. It is unclear what influences are present, but it is clear that there is not a 4-person majority for change in the present board of directors. When I set out to become a director in this community with a vision on how to repair damage caused by the choices of a few, a motto was developed that became the platform for our campaign. Your voice, your vote, your boardroom. I fought a room of 8 with a wingman, Don Moore, and voiced exactly what the community wanted, regardless of the repercussions. So much so that Don encouraged the engagements and supported them. The year passed, and just when I thought the fighting ended, a new battle arose. This time, the fights is on the 2 fronts simultaneously: the battle against the previous board of directors' decisions and the new battle of betrayal and dismissiveness of the community by the newly seated president, Don Moore. It's been 63 days since the election results, and no movement has occurred related to the hot button topics important to the community and its welfare. To be honest, of my colleagues and myself, others on the board of directors, including Don Moore, feel it better to negotiate something that is unlawful rather than nullify it completely. A plan we hatched with significant research and support, and motions were prepared in preparation to end this and other matters that plague our community. When this came to move forward and the healing process, Don Moore supported the stifling of those motions and topics by abruptly ending the open board meeting in July 2025. There was no explanation or apology thereafter, only silence and alienation. Our community suffers at the hands of these inactions. Fear is prevalent in the decisions made by the board of directors henceforth. Yesterday, Don shared his position on the trajectory of this community, and it is apparent that he is not focused on healing the community as a whole. He is focused on standing comfortably on a cushion of conformity and safety. Here is a short list of the important topics that were stifled before they could even be presented. Remove a FHPOA director per North Carolina General Statute A808H. Reversal of bylaws, rescinding the 67 supermajority percent rule. Addressing the unlawful signing of contracts by past FHPOA presidents. Addressing the Hosted America Easements Right Memorandum. Addressing the FHPOA manipulation of the Board of Director election in 2021. Addressing the validity of the Harbour Club Committee. Addressing the unlawful designation of the 2 Cara lots by a past FHPOA board decision. Addressing the unlawful designation of the 2 Royal Pines lots by a past FHPOA board decision. Addressing the unlawful removal of the common area of the 4 waterfront lots on the Gondolier Peninsula by a past FHPOA president. Reconfiguration of the parking lot for boat trailer parking. Addressing the capital expenditure expense overages for FY 2024 and 2025. Addressing the electronic monitoring via video cameras for FH membership. Development of a governance committee. Addressing the governmental outreach of the FHPOA management. Addressing the necessity for new legal representation. Addressing the necessity for a new community management. Amending the bylaws to provide membership input in future changes or modifications, maintain the POA offices in their centrally located position, redesign the north section of the newly built community center with community input. Your community requires bold decisions and strong leadership. Presently, it does not have either, nor will it have so long as this leadership stands. Efforts were made to sway the hierarchy of this board of directors with no avail. As we know, absolute power corrupts absolutely. That said, I have decided to step down as a director for Fairfield Harbour. This fight is more than one man can bear. As I stated earlier, fighting one fight is difficult yet doable with support and logistics. Fighting 2 fronts at one time in 2 different directions is impossible. This is not an environment that one man can win alone. There is no backup. There is no one coming to help. Trust is earned, respect is given, and loyalty is demonstrated. Betrayal of any one of those is to lose all 3. This is a difficult acceptance considering all the fighting and flaming arrows that were shot our way, landed on the shield I held in front of us. The platform on which I ran was your voice, your vote, your boardroom. It has become no voice, no vote, no action. Effective immediately, I resign from my position on the board of directors. Respectfully, Chris Barajas. And if that doesn't just... Well, I think we got some answers. There's been a lot of questions. Why did Chris step down? What are we doing here? I think, well, now we know. Let me remove these old. Oh, remove. All right, we're going to go to 6. I've got to, again, this is going to be a little clunky because I have to remove things because I can only have certain number of. And there are 19 attachments that we have not done. Okay, here is 6. This letter, also filed June 9th, is from, let me see if I can just, T. Smith. Dear Honorable Judge A. Todd Brown, I'm writing to you because I understand you are the judge assigned to Fairfield Harbour case. As a Fairfield Harbour resident of 15 years, I have witnessed many changes to the community, a place I call home, some positive and some negative. I am not a plaintiff in the pending lawsuit, but I am familiar with some of the bases of the lawsuit, i.e. the change to the bylaws to require a supermajority to remove a director. I am still not sure how this could have even been suggested, as the laws in the state of North Carolina to remove a director require 50% plus one votes. In my 15 years in this community, we have never, ever had 67% of eligible voters vote in any election, which is what I said in the last letter. Has that even ever occurred? Nor has any person won an election or any issue passed in the community with 67% voting for an individual or voting in favor or against an issue. It simply is not obtainable. And more importantly, history shows it's never happened. At the 2024 Fairfield Harbour annual meeting, Ms. Carmichael announced that the 2024 director election had the highest voter turnout in Fairfield Harbour history. Of the approximately 2,771 ballots sent out, the highest vote getter received 856 votes, or 30.96%. Since this bylaw change took effect, the board feels they can do as they please, and they know there is absolutely no possibility they could ever be removed from office. Their actions have become cavalier and are a direct result of them knowing it's virtually impossible to be removed. In the last 3 elections, the community has overwhelmingly rejected the direction of the board, and yet they continue to pursue their own agenda, knowing they will not be removed. As I'm sure you're aware, in July, 2 duly elected directors resigned, leaving the community with 2 board vacancies. On October 22nd, the present board held a candidates town hall. 5 fellow residents applied to fill those 2 vacancies. In my opinion, all 5 candidates would have served the community well. Sadly, to this date, the board has not appointed anyone, and no reason has been communicated to the community as to why they have not filled those vacancies. It's almost like the town hall didn't even take place. On October 20th, a fellow resident handed in over 350 signed petitions requesting a call for a special meeting to vote on moving the POA offices. I personally spoke with the woman who circulated the petition asking about the process. She said under the POA, she had 30 days to schedule a vote. To date, no vote has been scheduled, and the board has not told the community why no vote has been scheduled or what is the status of the special meeting. It's almost like the board is completely ignoring the receipt of the petitions. At the November 12th board meeting, a fellow resident inquired about the status of the special meeting, and they were told by the board a letter was sent out, yet neither myself nor any of my neighbors have received any such letter. I haven't received it. Once again, it's like the petition didn't even exist. Interestingly enough, at the October 22nd board meeting, the board voted on moving the POA office, even though they were aware ahead of time that the petition being circulated requesting for a community vote on this issue. On November 25th, a notice was emailed to the community notifying us that the board would hold a meeting on December 3rd. The sole agenda item to be discussed and voted on was an amendment to the bylaws. It was noted in the notice no community comment or input from the community would be allowed. No other information was provided on the notice regarding this meeting. At this meeting, the board voted to amend the bylaws from requiring a supermajority of eligible voters vote to remove a director to requiring 67% vote of the cast votes in favor of removal before a board of director member can be removed. Once again, the change of the bylaws is simply not obtainable. Even if you look beyond Fairfield Harbour elections to nationwide elections, there has never been a candidate who won by election of 67% margin. It's simply not obtainable and has never happened. If you take a look at the historical statistics on elections, in 1984, Reagan who won what is reported as a classical landslide election, received 525 electoral votes, and yet he only won the popular vote by 58.8%. The 2020 and 2024 presidential elections were two elections with the highest turnout in the past century. 2020, 66%, and 2024, 64%. And yet in 2020, Biden only received 51.3%, and in 2024, President Trump only received 50.8% of the popular vote. It is important to note again, at the 2024 Fairfield Harbour annual meeting, prior to revealing the director election results, Ms. Carmichael stated the election had the highest voter turnout in Fairfield Harbour history, with approximately 2,764 ballots sent out. The highest voter getter received 856 votes, or 30.96%. So how our board even begins to think a bylaw change in the best interest of the community is to consider a compromise is beyond comprehension. All they've accomplished is to make themselves unaccountable for their actions, knowing full well it's virtually impossible for them to be removed from office. On December 3rd, prior to the vote, the president read a written statement, and subsequently the POA sent out an unsigned statement to the community. I've attached a copy of this statement and hope you will agree this letter was simply an effort to vilify the plaintiffs of the lawsuit. I always thought what transpired at mediation sessions remained confidential, yet our board seemed to feel it was accepted to violate the confidential nature of the process. I have seen what this board and the direction and blessing of their attorney have done to my community, my home, and it's sad and shameful. This board's actions are nothing more than an attempt at self-preservation and certainly are not the best interests of the community. I thank you in advance for taking the time to read my letter. P.S. I ask you share this letter with the attorneys. You redact my name as I am afraid of the retaliation I might be subject to. This was the notice that was sent out for recollection's sake. Board of Directors meeting Wednesday, 12/3/25 at 11 a.m. in the community center. This was the link. The 5 sitting board members have called a meeting of the board for next Wednesday, December 3rd, with the open session of this meeting being held at the community center. Above is the link to watch from home, and the sole agenda for this meeting will be the discussion of a potential vote on amending the bylaws. Note, there will be no opportunity for public comment or input in the meeting. The board intends to adjourn to executive session immediately following the conclusion of the agenda item. Have a great evening, and we hope you all enjoy a happy Thanksgiving holiday. Statement from the directors on that December 3rd. The board statements regarding today's bylaw change amendment at the meeting held this morning is below, and the resolution is attached to this bulletin. The board has offered multiple times to amend the bylaws in an effort to settle and end the current litigation, both in discussions with the POA's attorneys and Mr. Collins, and directly with in very lengthy mediation. While the 5 directors are not in complete agreement on whether it is better for the POA to have a higher or lower bar for membership removal of directors, the 5 of us unanimously agree that it is the best interest of the POA this divisive litigation to come to an end. Unfortunately, the plaintiffs have not agreed to those offers of compromise, because it's not about compromise. It's about putting the power back in the hands of the community. Even without the plaintiff's agreement to dismiss the lawsuit, the board believes it is the right thing to do to put this amendment in place and document our offer of compromise. This is why I have made the motion, and I call the question. In simple terms, what this means is that instead of requiring 67% of all eligible votes to remove a director, now the bylaws require 67% of the votes cast, a much lower number. Okay. So, it's infuriating. It's infuriating. Okay, so that was attachment 6. I'm going to remove that. I'm going to add to stage. All right, so then Hope Carmichael sends in another designation of secure leave, and I won't read through this, but secure leave is requested to begin Monday, May 4th and conclude at the end of business on May 15th, and then again August 31st and conclude on September 14th. There's no other secure leave periods currently designated in the calendar year 2026, and she Again, make sure that this is not designated for the purpose of delaying, hindering, or interfering with the timely disposition of this matter or any pending action or proceeding. So let me remove this. Okay, that was 7. Let me add some more here. We're going to go 8. Open. We're going to go 9. Open. We're going to go 10. I'm just going to get them all loading. Open. We're going to go 11. Open. We're going to go 12. Open. All right, here's 8. Defendant's brief in opposition to plaintiff's motion to amend complaint. So they are opposing the amended complaint. Defendants, Fairfield Harbour Property Owners Association, Howard Les Pendleton, Robert James Brody, Lawrence W. Basin, and Susan Debra Harris, in their capacities as officers and directors of Fairfield Harbour Property Owners Association, Inc., submit this brief in opposition to the plaintiff's motion to amend complaint and plaintiff's brief in support of their motion to amend complaint. Plaintiffs seek to amend their complaint for the second time to add already known factual allegations, 3 new defendants, 2 new causes of action, breach of fiduciary duty and breach of contract, and a demand for punitive damages. This wholesale restructuring of the complaint comes nearly 7 months after the court's amended deadline, more than 9 months after their first amended complaint, and after substantial motion practice in connection with their preliminary injunctive relief. Such an amendment would prejudice defendants, disrupt the established case management timeline, and reward plaintiffs' inexcusable delay. Accordingly, the court should deny plaintiffs' request to amend their complaint. Facts: Plaintiffs filed their original complaint the 9th of February 2025, alleging that the defendant's June 2024 amendment to the bylaws violated North Carolina law and defendants' actions governing documents. Plaintiffs then filed their first amended complaint on March 26, 2025. Over 9 months passed before plaintiffs filed their current motion to amend the complaint in brief in support on 7 December 2025. In their proposed second amended complaint, plaintiffs seek to add 3 new additional defendants as parties who are current board members: Don Moore, Lee Fawcett, and Michael Foster. Plaintiffs also seek to add allegations related to a December 3rd, 2025 amendment to the bylaws relevant to this present lawsuit, which changed the threshold for removal of 67% of all eligible votes as amended in June 2024 to 67% of votes cast. A February 2025 assessment to owners and members of Fairfield Harbour for legal fees. That was the $50 assessment that we got in 2025. And a vote to approve the clubhouse project in Fairfield Harbour community that occurred years before the present lawsuit. Additionally, plaintiffs seek to add entirely new claims for breach of fiduciary duty, breach of contract, and punitive damages. Plaintiffs contend in their motion to amend and supporting brief that the proposed second amended complaint is necessary to reflect the current factual developments in the case, and the defendants will not be prejudiced because discovery has not yet been undertaken. Plaintiffs further assert that their amendment is necessary to name current board members and address the 3 December 2025 bylaws amendment. As demonstrated below, the contentions lack merit and cannot overcome the undue delay, prejudice, and untimeliness of plaintiff's motion. Legal standard. Rule 15A of the North Carolina Rules of Civil Procedure provides that a defendant may amend his pleading once as a matter of course at any time within 30 days after it's served. Otherwise, a party may amend his pleading only by leave of court, and leave shall be freely given when justice is so requires. Although Rule 15 of North Carolina Rules of Civil Procedure states that leave to amend shall be freely given, leave is not automatic, and North Carolina courts have consistently held that the rules still protect parties who may be prejudiced by the amendment. And then they give a court case. Generally, a trial court should grant a party leave to amend a pleading absent a showing of material prejudice. Another case backing that statement. However, courts routinely deny motions to amend when any of the following factors are present: undue delay, bad faith, undue prejudice, futility of the amendment, and repeated failures to cure defects by previous amendment. North Carolina courts have consistently held that a trial court may appropriately deny a motion for leave to amend the basis of undue delay where a party seeks to amend its pleading after a significant period of time has passed since filing the pleading and where the party offers no credible explanation for the delay. I'm trying to pick up where it leaves off. See Media Network, blah, 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 2009, affirming denial of leave to amend where defendant filed motion 3 months after filing answer and offered no credible explanation for the delay. North Carolina App 387402, affirming denial where there was nothing in the record to explain why the plaintiff waited until 3 months after the defendant filed an answer. This other case affirming denial of leave to amend where the record did not indicate why plaintiff waited 3 months from filing of answer before moving to amend the complaint. In KRG New Hill Place LLC versus Springs Investors in North Carolina, business court denied proposed amendments to pleadings after finding the plaintiffs unduly delayed seeking the amendments that offered no explanation why the information contained in the amendments would not have been available to them at the time they commenced the lawsuit. Similarly, in Kissports LLC versus Munn, the court concluded that the plaintiff's motion for leave to amend its Second Amendment complaint was the product of undue delay because the plaintiff offered no reasonable explanation for the delay, noting that the plaintiff could have asserted the additional claim at least as of the time of its amended complaint a year earlier. In Media Network, Inc., the North Carolina Court of Appeals affirmed the North Carolina court's order denying the defendant's motion to amend to add counterclaims of fraud and UDTP based on undue delay. The business court found, this is why they wanted it moved to the business court, and that was declined. The business court found undue delay because defendants knew the relevant facts surrounding those additional counterclaims before filing their original pleadings and waited almost a year from the filing of their first action to seek leave to amend. Capital Investors versus Broyhill Furniture, affirming denial of motion to amend when claim could have been raised in earlier pleading based on the information already known to the plaintiff. Hold, please. My ankle is throbbing, and I'm going to take this brace off. Sorry, that's all I can think about. I'm reading, and I am thinking about how bad my ankle hurts. For those that don't know, I broke my ankle last week. I love the comments. Thank you so much. And I can gab all day long. You know about that. Hope is the top POA lawyer in the state. That is a true statement, or so they say. I can neither confirm nor deny that. I can only attest to what I have seen her do physically at our meetings, and that leaves a lot to be desired from my point of view. Okay. Oh, good question. Sorry, I haven't been looking at questions I've been reading. Do they record voice or video their closed sessions to back up the written notes? They do not. Executive sessions and other things are not recorded to my knowledge, and they are not included in the minutes unless there are decisions made and then notes. It's just the decision is noted. Good questions. Okay, let's talk about Here, the timeline is even more egregious. Over 9 months have passed since the plaintiffs filed their first amended complaint, and over 10 months since the plaintiffs initiated the lawsuit. Most significantly, plaintiffs seek to add entirely new claims for breach of fiduciary duty, breach of contract, punitive damages based on facts they have known for nearly 1.5 years. But that's not true, right? Because it's just not true, because some of these things happened since the first lawsuit happened. Like, that's why they're being added. These are to bring the facts to current, right? What's currently happening. The amendment does not merely refine existing allegations, it seeks to add fundamentally different claims that could and should have brought their original complaint, or at least in their first amended complaint filed 9 months ago. Yet plaintiffs had not provided a reasonable explanation for their inexcusable delay. Plaintiffs vaguely assert in their motion and briefly that I love this because it's allegations and shade, right? Like, this is just throwing shade at the opposite side. So it's just funny to me. Plaintiffs vaguely assert in their motion and brief that their second amended complaint is necessary to reflect the current factual developments in the case. That is a true statement. That is what we're doing here. However, no factual developments have arisen to suggest the addition of claims for breach of fiduciary duty, breach of contract, or other derivative action or punitive damages. These newly sought causes of action are based on facts known to the plaintiffs as late as of June 2024, over 1.5 years ago. And that's not true. You didn't assess the $50 legal fee assessment until February of 2025. And we just got these new board of director members. Like, this is ridiculous. Okay. I digress, because this is their version of what's happening, and I should just be reading it as such. But just know, you can side-eye it like this. Although it is true that defendants amended their relevant bylaws on 3 December 2025, plaintiffs' argument related to the bylaws amendments remained the same, as defendants did not amend such bylaws to revert back to the 2020 bylaws that required a simple majority of votes cast to remove a director. In other words, tell us in other words, that December 3rd, 2025 bylaws amendments is the same alleged violation as that of the June 24th bylaws amendment included in the original and first amended complaint, as the relevant bylaws still do not set the removal requirement at a simple majority of votes cast. That's what you said. I'm going to try to not cuss. Plaintiffs seek to add an allegation in support of their complaint about defendants assessing a legal fee to owners members of Fairfield Harbour, but this assessment happened in February of 2025, which was before plaintiffs filed their First Amendment complaint. Plaintiffs also seek to add allegations surrounding defendants' vote to approve a clubhouse project in Fairfield Harbour community, which occurred years before the plaintiffs filed both their original and First Amendment complaint. Moreover, plaintiffs assert in their proposed Second Amendment complaint that defendants continue to make decisions affecting all parties to date without providing any specifics. Well, specifically, they were added. As the court held in Zagaroli versus Neal, a plaintiff's motion to amend is the product of undue delay despite plaintiff's contention that the motion to amend was based on facts learned through discovery, where the plaintiffs fail to offer any support or citation to support such contention. The plaintiff's amendment will cause undue prejudice to defendants. How do we think that's going to happen? How are we going to cause undue prejudice to these new defendants? North Carolina courts routinely deny a motion to amend when the proposed amendments involve new defendants or new, separate, and distinct claims that would require additional or different discovery. See Global Textiles Alliance versus TDI Worldwide, or Stetzer versus TAP Pharmaceutical Productions, finding the trial court did not abuse its discretion in denying a motion to amend that would involve more discovery for the parties, slow the litigation process, and present a more unwieldy litigation for the trial court to administrate. Kissports LLC at 3, concluding that the proposed amendment would cause undue prejudice where it changed the nature of the damages sought, reshaped the available defenses, and greatly increased the stakes of the lawsuit. In the present case, plaintiffs proposed the amendment substantially prejudices defendants. The new claims of breach of fiduciary duty, breach of contract, and punitive damages are separate and distinct from the existing claims for declaratory judgment and injunctive relief requiring entirely different evidence and discovery. This represents a wholesale rather than minor restructuring of the present lawsuit, which will increase costs, delay resolution, and complicate trial administration, which is materially false. If you've been tracking, and for those joining, I'm seeing this number just go up on my side. I am going through, this is the opposition by the defendants to the second amended complaint. And we are just kind of catching up on everything that happened in January 2026 and February 2026. Okay. So I'm on page 8 of this opposition by the defendants. Okay. The prejudice is particularly acute because plaintiffs seek to add claims requiring extensive discovery into board members' decision-making process, communications, and motivations. Defendants have no reason to undergo this discovery under the existing claims. Adding punitive damages compounds this prejudice by necessitating discovery into defendants' subjective intent and financial condition, along with additional depositions, document requests, expert witnesses regarding damages, and defendant associations board governance. Defendants cannot fairly be expected to defend against claims knowingly withheld for 9 months while substantial resources were devoted to briefing preliminary injunctive relief on the declaratory judgment claims alone. A motion for leave to amend is futile and appropriately denied when the proposed amendment could not withstand a motion to dismiss for failure to state a claim. Sorry, I just had a flashback to Legally Blonde. That is the failure to state a claim is a direct quote from that movie. The futility standard under Rule 15 is essentially the same standard used in reviewing a motion to dismiss under Rule 12b-6, but provides that court liberal discretion to find that an amendment lacks futility. Simply the Best Movers LLC versus Marin's Moving Systems. A claim should be dismissed under Rule 12b-6 when 1. The complaint on its face reveals no law supports the plaintiff's claim, 2. The complaint on its face reveals the absence of facts sufficient to make a good claim, or 3. Complaint discloses some facts that necessarily defeats the plaintiff's claim. Here, the plaintiffs assert that the 3 December 2025 amendment is unlawful because it was passed unanimously by the association's board of directors rather than the association's members. And 2, it did not revert the bylaw to conform with North Carolina General Statutes 55A-8-08, which requires only a majority of votes to cast to remove a director. To the extent based on the purported unlawfulness of the 3 December 2025 amendment, the proposed second amended complaint is futile because it reveals on its face that no law supports the plaintiff's claim. The bylaws of a voluntary association are a contract between the entity and its members over which traditional rules of contract interpretation governs. See Master versus Country Club of Landfall. If the contract is clearly expressed, it must be enforced as it is written. Articles 9 of the Defendants Association bylaws states that the bylaws may be amended by the affirmative vote of 5 of 7 directors of the board. The December 3rd, 2025 amendment to the bylaws was unanimously approved by all 7 directors of the Defendant Association. The bylaws vest amendment authority solely in the Defendants Association's board, and the plaintiff's assertion that the members were entitled to vote on the amendment is contrary to the clear language of the bylaws. Plaintiffs attempt to rely on sections 55A-7-23 and 55A-10-21 of the North Carolina General Statutes for the proposition that the amendment procedure set forth in the bylaws is invalid, but such reliance is misplaced. in 55A-7-23 of the North Carolina General Statutes, it says an amendment to the Articles of Incorporation or bylaws on which members are entitled to vote, the purpose of which is to increase or decrease the vote required for any member action, shall be approved by the members entitled to vote on that action by a vote would be sufficient to take action before the amendment. It always seems like words are so hard here. North Carolina General Statute 55A-7-23, Section 55A-10-21 states, if the corporation has members entitled to vote thereon, then, unless the chapter, the Articles of Incorporation, bylaws, the members acting pursuant to subsection B of this section, or the Board of Directors acting pursuant to subsection C of this subsection, require a greater vote or voting by class, an amendment to a corporation's bylaws to be adopted shall be approved by the board or in lieu thereof in writing by the number or proportion of members entitled to vote under General Statute 55A-7-02, a meeting to call a special meeting considered such amendment by members entitled to vote thereon by 2/3 of the votes cast or a majority of the votes entitled to be cast for the amendment, whichever is less, and in writing by any persons whose approval is required by a provision of the Articles of Incorporation authorized by General Statute 55A-10-30. North Carolina General Statute 55A-10-21A, emphasis added, the plain language of members entitled to vote found in both statutes is properly interpreted to mean that the statute only applies when members have an existing legal or structural right to vote on an amendment in question. The association's members have no such right. I'm going to read that again. That's important. The way she's explaining it here is important. Even if we don't agree, it's important for us to know and understand from the perspective of the defendants here. The plain language of the general statute, members entitled to vote, found in both statutes, is properly interpreted to mean that the statute only applies when members have an existing legal or structural right to vote on the amendment in question. The association's members, that's us, the community, have no such right. Defendant Association's bylaws only entitle its board of directors to vote on bylaw amendments. And as such, the 3 December 2025 amendment was purely within the discretionary authority of the Defendant Association's board of directors. Plaintiffs are also mistaken in that their claim that North Carolina General Statute 55A-8-08 controls and requires only a majority of votes cast to remove a director. Except as provided in subsection I of this section, a director may be removed under subsection A or B of this section only if the number of votes cast to remove the director would be sufficient to elect the director at a meeting to elect directors. The statute merely provides that the threshold for director removal may not be less than required for election. Let me read that again. The statute merely provides that the threshold for director removal may not be less than that required for election. The language does not bar an association from setting a bar higher as long as the higher threshold does not conflict with the minimum standard in the statute. Said differently, a director cannot be removed with fewer votes than it would take to elect them, but an association can require more, assuming no other part of the law says otherwise. Defendants should not be required to defend against claims that are, on their face, so clearly unsupported by law. And I don't think that's true. I don't think this is unsupported by law. I think this case between Fairfield Harbour community members and the POA stands to set a precedent, right? This is important because no law currently states that, but that's not to say that this lawsuit could not in effect set a new precedent for how boards are set to read these. I think it's this is up to our interpretation at this point. Hope and the board obviously have a different perspective than the plaintiff's lawyer and many of us in the community, right? So it's not that they are not supported by law. I think a law does not exist to say otherwise. Plaintiff's motion to amend is untimely under the court's current case management order. The court entered its case management order on the 23rd of May, 2025. Under the case management order, the amendment to pleadings deadline is 28 May, 2025. This date was never modified or extended, yet the plaintiffs filed their motion to amend nearly 7 months after this deadline expired. The court subsequently entered its order for defendant's motion to amend case management order on December 17, 2025. Critically, this order does not amend the amendment to the pleadings deadline. The order only modified certain other dates, specifically those for discovery, post-discovery, dispositive motions, and mediation. The order explicitly states, except as provided in this order, the case management order entered on 23rd of May, 2025 remains in effect. The amendment deadline was not among the deadlines modified. Plaintiffs have not filed a motion to modify the case management order to extend the amendment to pleadings deadline as explicitly allowed under BCR 9.4. Plaintiffs have also not filed any motion to extend the time period for the amendment to the pleadings deadline as expressly required under BCR 4.1. Moreover, since the time for amendments to pleadings under this court's case management order has expired, plaintiffs must accompany such a motion with a brief pursuant to BCR 7.2, 7.10. Plaintiffs have taken none of these steps. Instead, they simply filed a motion to amend nearly 7 months late, hoping the court will overlook their procedural failures and expired deadlines. Plaintiffs' procedural end run cannot succeed. Case management orders exist to provide structure, certainty, and efficiency to litigation. Allowing parties to ignore deadlines whenever convenient would render such orders meaningless. Allowing plaintiffs to amend their complaint a second time will greatly disrupt the case management under both parties agreed to follow in this lawsuit. All right, so this case that they referenced denying the plaintiff's motion to amend in part because the amendment, if allowed, would disrupt the case management order that both sides had agreed to follow. The present case is readily distinguishable from the previous cases where courts permitted a party to amend despite noncompliance in a case management order. Those cases involved situations where facts were learned after the case management order's deadline for amendment to pleadings and could not have been discovered early with reasonable diligence. See, this case permitting defendants to amend where the facts underlying counterclaims were discovered after a deadline for amendment to pleadings and could not have been discovered earlier with reasonable diligence. In this case, showed good cause may be shown if the plaintiffs uncovered previously unknown facts during discovery that would support additional causes of action, or if despite the exercise of reasonable diligence, the evidence supporting the proposed amendment would not have been discovered until the amendment deadline had passed. Here, by stark contrast, all facts supporting plaintiffs' proposed amendments were known to plaintiffs well before the 28th May 2025 case management order deadline. Indeed, plaintiffs knew almost all of these facts, almost all, not all, even before they filed their first amended complaint on the 26th of March 2025. The June 2024 bylaws amendment, the clubhouse project vote, the February 2025 assessment, and the composition of the board were all matters of public record and directly known to the plaintiffs. Even the 3 December 2025 bylaws amendment does not constitute new factual basis because it represents the same alleged violation already challenged. Plaintiffs had every opportunity to assert their proposed new claims months ago. They chose not to do so. That strategic choice cannot now excuse their violation of the court's deadline. Conclusion. For the foregoing reason, defendants, Fairfield Harbour Property Owners Association, Howard Les Pendleton, Robert James Brody II, Lawrence W. Baisden, and Susan Debra Harris, in their capacities as officers, directors of Fairfield Harbour Property Owners Association, respectfully request that this court deny the plaintiff's motion to amend the complaint. And that was dated the 20th of January, 2026. Okay. These were certificates of service. Okay, great. Now, so that was 8. Let's add to the stage 9, I think is another letter. This is from the Dreschlers, William and Sandra. So filed January 28th. So we're now towards the end of January. Dear Honorable Brown, my husband and I are active members of the Fairfield Harbour community. My husband Bill, since he bought a condo in 1985, and me since Bill and I bought a house in 2012. Bill experienced adverse times in Fairfield Harbour in the past with lawsuits and negative residents, but nothing compares to the outrageous dissidence we are currently experiencing from a small group of loud, boisterous people who want to change basically everything in our community to fit their narrative. Fairfield Harbour is a wonderful community loaded with positive, fun-loving residents who socialize with each other and help residents at the drop of a hat. True statement. Fortunately, that part of the community still exists. Unfortunately, the plaintiffs who sued the POA and numerous prior and current board members continue to play mind games to tear this community apart for whatever reason, personal reasons they have. Let me make it perfectly clear. The plaintiffs in the lawsuit do not speak for me. And which is why you're not part of the plaintiffs. And although they appear to insinuate in their second amended lawsuit that they are working for the good of the community, let me make it perfectly clear that the plaintiffs in the lawsuit are not working on my behalf, nor have I ever asked them to work on my behalf. From my observations, this lawsuit is the result of 71 Fairfield Harbour property owners, mainly new residents, being riled up, misled, and convinced to follow a man on a personal mission. Even if where did she get that quote? A man on a personal mission. Even if that mission changes with the wind. I'm sharing this information because my husband and I know the man personally. Who's the man? Listen, we have so many plaintiffs in this thing, and we have so many letters and current past board members. You got to explain who the man is. I can't even, in my mind, I was thinking Chris Barajas, but knowing of several men in our community who want change for our community, I don't know from their perspective who the man is. That's interesting. I'm sharing this information because my husband and I know the man personally, and we were good friends with the man and his wife for years. We actually encouraged them to move to Fairfield Harbour, not knowing what damage they could do to our beautiful community. You were friends with them for years, and invited them to move to the community, yet you did not. I'm letting that sink in a second. We knew he was a know-it-all. Oh my God. We're calling names now. We knew he was a know-it-all and didn't like to be challenged. But we put all that behavior aside because they were our friends. We now understand that a person with that kind of personality always has to have a mission and relishes convincing people that they know best. Unfortunately, that's where we are. I am so flabbergasted. You were friends with these people for years and dismissed what you perceived to be bad behavior because they were friends, invited them to join our community. I would love to know who this man is. And you don't even say his name, but yet you will basically call out every man in our community, none of us knowing who he is. Sometime in 2023, my husband and I watched the man on a mission, our former friend, get his posse together. Oh my God. We have posses in Fairfield Harbour. Get his posse together and start boasting that he knew what was best for Fairfield Harbour. You know, that's so funny because I remember Phil saying at one point that he knew what was best for Fairfield Harbour. Is he the man? I can't imagine. Was Phil the man? Who's the man? You are throwing so much shade at this person, and we don't even know who you're talking about. Sometime in 2023, my husband and I watched this man on a mission, our former friend, who they invited to come to our community and buy a house, got his posse together and started boasting that he knew what was best for our Fairfield Harbour, like he did in his prior community. The man, still in quotes, no names, established a FH Stop group, Stoppers, Minions for the Man. The man designed the FH Stop website. Keep in mind, FH Stop was for stop the open, like save the open places. Like all we were trying to do was not have a community built on within the community and save our open space. Like FH Stop stood for Fairfield Harbour, save the open spaces. That's what it stood for. But he got his stoppers, his minions for the man. The man designed an FH Stop website. Very early on, the man opened a GoFundMe legal fund showing that he was ready for a fight. Are we talking about Daniel Ritter? Who I'm trying to remember who opened the original group me for or a fund me for FH Stop. I don't remember who that was. Like who opened it. It was obvious he wanted his way, whatever that was, because, like I said, his mission changes with the wind. The man did not intend to discuss or negotiate anything. A petition was put out to remove 2 board members just 2 months prior to elections in 2024 when their term expired, costing the community unnecessary dollars. Numerous propaganda letters, and to be real clear, the petitions went out well in advance of the 2 months of the elections. It was not acted upon until 2 months prior to the election. So a lot of that accountability falls on the then sitting board. Numerous propaganda letters full of misinformation were distributed. Let us vote signs showed up in a few lawns, and it was not a few lawns. Judge, if you're watching this, it was a lot of lawns. Let us vote signs showed up on a few lawns and on some vehicles. It was more than a few. It was a lot. And even down Broad Creek, people who don't even live in our community, but support the ongoings within our community because we all live geographically proximate to one another. This was not just impacting what was happening within our community. This impacts everything that happens up Broad Creek from us. Stoppers went to door, spreading misleading information and guaranteeing a reduction in dues if residents signed the petition. For the first time in Fairfield Harbour history, the Stoppers sold political lawn signs endorsing their 2 POA board candidates. The Stoppers set the stage for a very contentious POA board election, something Fairfield Harbour had never experienced. I had tracked the case evidence in lawsuits since it was filed. By my records, 39 of those misled property owners with misinformation from the lawsuit, leaving only 32 original plaintiffs. That speaks volumes. Many of these 32 finally realized that they were following the wrong man and that it was a frivolous lawsuit. And that's not my understanding at all. I think some pulled out from the financial obligation perspective. I know I spoke with one specifically who pulled out, and it was not because of anything happening here, but because of the stress it was imparting on their lives, and they just needed a mental health break. I don't think it was anything regarding for some, I don't think it was anything regarding misleading information. And of the initial 71 plaintiffs, 35 of them moved to Fairfield Harbour in or since 2019. That means 49% of the plaintiffs moved to Fairfield Harbour after Florence. Therefore, they have no personal knowledge of, 1, the true culture of FH prior to and during Florence. What does that have to do with the price of tea in China? The issues with the Mid-South, the owners of Fairfield Harbour amenities for years, the community cohesiveness themselves when a decision was made to purchase the 385 acres amenities from Mid-South, the recommendations from the consulting firm in Raleigh regarding the plan for the 385, the years of planning the Harbour Club, the number one recommendation in the plan for the 385. She uses the a lot, or they use the a lot. In conclusion, an insignificant number of residents, 32 property owners, and that is not true. This is not a true statement at all. An insignificant number, 32 property owners out of the potential 2,800, about 1%. And that is not true. There are a lot of people that just financially cannot join the lawsuit or don't for one reason or another, but that fully back what is happening within the plaintiffs. I mean, how many people showed up to the breakfast this morning even, right? Like, this is not just that. This is not just 32 people. They're attempting to change the entire culture, management company, current legal counsel, bylaws, etc. of a 55-plus-year-old, well-established community. The frivolous lawsuit needs to be dismissed, and it will be dismissed or put aside whenever we get our... All right, that was letter 9 from Bill and Sandy Dreschler. I'm going to remove that from the studio. Here we go. This is from Debbie Rothengast. Dear Honorable Todd Brown, I write as a 10-year resident of Fairfield Harbour and the spouse of John Rothengast, who was the subject of a petition for removal without cause by plaintiffs mere months before his term as Board of Director Vice President was ending. He had been duly elected on a platform of rebuilding the community clubhouse following service for several years on the clubhouse committee after it had been identified by previous boards as a community need. Allowing this letter to serve as evidence of the human toll that this small group of individuals has wrought on this community and who have consistently disparaged, libeled, and slandered a good man, whether through social media or meetings. John was a volunteer who also served on the litter cleanup crew, who brought 40 years of expertise as an accountant and experienced controller to Fortune 500 companies. He also served on the boards for other diverse communities. His handful of plaintiffs in a community of 2,800 properties do not represent a majority and certainly do not represent us. It's so funny, though, because a majority voted out this prior board member. It was a majority, and then it was changed to the supermajority. Many of the plaintiffs are new residents or new to living in an HOA. One plaintiff posted on social media that someone needs to go to jail in relation to a rumor that money was missing. Later, it was proven that no money was missing, but neither was there a public apology. As a retired litigation specialist for commercial insurance carriers, I would never jeopardize my 31 professional licenses. Neither of us will volunteer in this community again after the unnecessary debacle. We will use our energy, resources, and time elsewhere. Unfortunately, many qualified homeowners feel the same way. Okay. Let me remove this. All right. So this is the defendant's brief to opposition of plaintiff's motion. With an offer to extend the deadline. And I don't think, how many pages is this? 13. I'm going to save this. I want to get through the letters, but this is important. Remember number 9. I'm going to write it down. 9. All right, this is by Daniel Ritter. To the judge, thank you for helping us restore our rights as residents and property owners in Fairfield Harbour. We were not allowed to vote on the change to the bylaws as required. The whole community has lost respect, and we feel we have unfairly been taken advantage of by the board of directors at that time. Ruling in favor of the community would begin the process of healing the community so we can continue to have the same control of the destiny of our community. All right. I think this was 10. No, 12. All right, let's add the next set. 12. 13. Oh, man. 14. I'm seeing the comments. I'm going to save them for a second while I get these uploaded. 15. $16. I have to say, Dan, your letter was really short and sweet, man. 16, 17. I'm going to try to get 18 and 19 pulled up here too. Let's see if it'll let me. Those 18 and 19 are the last two. $18. And $19. All right. From the desk of Frank Unetic. So this came in February 24th was the date it was filed. It was dated February 12th. Dear Judge Brown, we have lived in Fairfield Harbour since September 2021. We own the house located at 1317 Carricara Drive. We joined the lawsuit since near the very beginning. The reason that we joined the Fairfield Harbour Property Owners Association does not respond to the community residents in any form. The new clubhouse with the accompanying debt is the biggest and cleanest example. I believe their justification was a survey, not an actual recent vote, that the survey was completed a few years ago before we moved to the community. That data was then used to justify the spend. The initial pitch and or renderings as we moved in included a pool and other nice amenities. When that building was completed, they indicated there were no funds available to flush out the amenities or the pool. I spent 28 years in the U.S. Navy. I spent 28 years in the U.S. Navy as a Navy captain, 06. I was in the submarine force with many leadership tours, including command at sea. My last tour was of a large shore command, 2,500 people, well over $2 billion in operating authority during my naval career. I learned that you start to ask questions and you feel they're not getting to the root cause. There is something people are hiding. I fail to understand why, for a non-paying voluntary assignment into a POA leadership position, why are they fighting this tooth and nail? Given all that has been going on, I think there is something the leadership is hiding and or bad advice was given. I can fully understand the reluctance to allow for the continued churn in the leadership. However, those people do not serve what the community desires, and they should be removed. I'm trying to get this one thing out of my face so I can read. I can fully understand the reluctance to allow for continued churn in the leadership. However, if those people do not serve what the community desires, then they should be removed in accordance with state law and practice. Based on my house on various realtor websites, property values have declined due to the ongoing infighting and poor POA leadership. Word of this has gotten around New Bern area. I have seen these types of comments on various websites and blogs, for example, Nextdoor. The last item I would offer for consideration is the cost of annual dues. While I don't have the exact demographics for Fairfield Harbour based on various blogs, etc., the majority of individuals are on a fixed income. The dues have gone up considerably. In the 4 years that we have lived here, in the house we bought in 2021, the dues were listed to be around $800 per annum. Those dues are now closer to $1,500 per annum. We just had a $93 per annum increase realize that on a monthly basis, that is $125 for those on a fixed income, the declining property values, and the increase in our annual dues for little to no extra amenity is a tough budgeting pill to handle. During my Navy tenure, I did have a tour as a resource sponsor, one who deals with budgets for various program offices. I fully understand the need to deal with increasing costs due to inflation, but a near doubling to 4 to 5 years is a tad much. I have seen no public attempt to control costs from the leadership in the POA, only to pass on the additional costs to the community. They only pass on the additional costs to the community. I believe this methodology also reflects on the poor leadership of the POA, and yet another reason to allow for removal of non-performing leaders. Thank you for helping us restore our rights as residents and property owners in Fairfield Harbour. Let's add this one. This was filed written February the 11th and filed on February 24th. Dear Judge Brown, we are writing to you as plaintiffs in the above mentioned litigation. I am writing on behalf of my mother, Mary Beth Harris, a resident of Fairfield Harbour since 2008, and myself, Kathleen Monroe, her daughter, having moved in with my mother in December of 2022. It has become clear to us in early 2024 that the then President Phil Hewitt and Vice President John Rothengast, along with other members of the board of the POA, were not acting in the best interest of the community. They were acting on their own selfish interests. They launched several major costly projects in the harbor, including an incredibly overpriced, underserving clubhouse, really more of an office building without a community vote, while drastically raising dues and placing the community into debt for the next 15 years. They also suggested that they would be building a separate community within our community on open space known as the 385, again without any input from the community vote, without notification to the neighbors bordering the green spaces that they plan to develop. The 385, as we call it, is commonly owned by all of the residents here. So when the entirety of a collective of residents that rose up in protest against these patio homes being created, FH Stop, Fairfield Harbour Save the Open Properties, thank you, we became involved in the fight to have residents' opinions heard and to be granted resident votes on these major projects that, 1, use our dues money, 2, affect our lives, and 3, affect property values here. We also joined with FH Stop to have Phil Hewitt and John Rothengast unelected, as they seem to be the driving force behind what they called a vision without any real clarification on what that vision is. See how we call people out by name? Remember that other letter that just referred to the man over and over again in quotes? We got to know who you're talking about here. This is not a fancy retirement community. Most people who live here on basic fixed income, so to have decisions made that affect the financial solvency without having any say in the matter is unconscionable. Most people who live here consider themselves to be in heaven's waiting room. And yet when Phil Hewitt was challenged about the increase in dues for this clubhouse, very few people wanted, he replied, if they can't afford to live here, they can move. That was a direct quote. Yet almost all of the residents here have lived here long before he moved here in 2016. We were successful in having them removed from office. That was Phil Hewitt and John Rothengast, and having 2 members promoted by FH Stop to join the board. However, with a board of 7 people, the 2 new members were outnumbered in a vote to then change our bylaws to require a vote of 67% of residents voting to remove someone from the board, from the previously stated bylaw that required 50% plus 1 votes. This grants them almost non-negotiable indemnity and license to do as they please with other people's money with no accountability. They made this decision on their own with counsel from Hope Derby Carmichael of Jordan Price Wall Gray Jones, the attorney for Fairfield Harbour, who endorsed this illegal change without notifying the residents and without a vote from the residents. This is in direct violation of our bylaws. It's immoral and we understand illegal in this state. Yet when challenged, they've dug their heels in and are going about their business as they would like to see it happen, pushing through the clubhouse that the residents didn't get to vote on and most didn't want in format in which it was presented. And the current board, much like the previous board, retires often to executive session where residents are not privy to the conversations about our community and the decisions being made on our behalf. All we have asked for is to be included in the conversations, to be able to weigh in on the decisions, like the amenities to be included or not in the clubhouse, and to have a vote on major projects and expenditures in our community. We respectfully ask that you uphold North Carolina law and decide for the plaintiffs in this case. Signed, Mary, Beth, and Kathleen. All right, here's the next one. Kathy Bellarose. Oh, I got to make this bigger. I am writing to support the lawsuit to restore the rights of homeowners in Fairfield Harbour, New Bern, North Carolina. In addition, I would like to relay my concern that the FHPOA Board of Directors has not followed the procedure as it relates to North Carolina general statutes. In 2013, I moved to Fairfield Harbour. At that time, Fairfield was a cohesive community. Although there were varying opinions and disagreements regarding the best direction for our community, there was never the lack of transparency seen from the board of directors in the last couple of years. There were even other lawsuits filed against Fairfield Harbour, but never the lack of trust seen now by more than half the homeowners. I have never seen board members voted out of office until recently. I have never seen board members change the percentage of votes it takes to remove a board member out of office from 51% to 67% without input from homeowners. It was so clear that this was done to keep certain members on the board. Even after two board members, the president and vice president, were voted off the board. They ran for the board again, and they lost. The vote to remove them was a lack of confidence by most of the homeowners in these board members. Homeowners have not been allowed to vote on major expenditures. We have a new community center costing millions that homeowners were not allowed to vote on, even though homeowners requested a vote. Accounting was manipulated so that the board could state that they did not legally have to ask homeowners whether they wanted to spend money on a brand new building when there are other structural priorities that Fairfield Harbour homeowners are concerned about, like the outdated drainage system. I am a nurse, not a lawyer. However, it seems to me that the POA lawyer, Hope Carmichael, should not be involved in this case. She gave the board of directors legal advice regarding the change in percentage to vote no confidence board members off the board. It seems to me that this is a significant conflict of interest. She has complicated the case, thereby costing Fairfield Harbour more when this money needs to be allocated for significant updating of structural issues within our community. Lastly, I would like to thank you for listening to homeowners' opinions. This is refreshing since many of us do not feel heard by the board of directors or frankly by the legal system, since the lawsuit has gone out on way too long and cost our community significantly. Unfortunately, not only has the lawsuit been costly for our community, but has been prohibitive to those of us who cannot afford to pay for long, lengthy lawsuit. I mean, that's right. Okay. Let me see. Is this a letter? Yes. Brenda Singh and Gerry Riffle. Okay. So this was written, I don't see the date it was written, but it was filed February 24th. We, the undersigned residents of Fairfield Harbour, Brenda Singh and Gerry Riffle, respectfully submit this letter to highlight a persistent and systemic breakdown of corporate governance and fiduciary responsibility by Fairfield Harbour Property Owners Association Board of Directors. The following facts demonstrate a pattern of conduct that has deprived residents of their rights and violates established procedures. Facts and concerns. 1, financial liability without consent. I love the format of this. The board placed community into a debt of at least $6.5 million plus interest for the Harbor Club without allowing a community-wide vote, bypassing the membership's right to vote to oversee large-scale capital expenditures. Bylaw by electoral irregularities. We move for a return to the 50+1 simple majority rule, which has historically been the standard since Fairfield Harbor's inception and is vital for ensuring equitable representation. Unauthorized agreements. We request a judicial review of concerns regarding the unlawful signing of contracts by past FHPOA presidents without proper board or membership oversight. The current path of the FHPOA is not focused on healing the community welfare, but rather on ignoring the legal rights of the residents. We respectfully request that the court intervene to ensure the FHPOA adheres to North Carolina Planned Community Act and restores the democratic protections guaranteed by our governing documents. We, the undersigned, respectfully request that the Honorable Court grant the following preliminary and permanent relief. 1, a forensic audit, an order requiring the independent forensic audit of all loan documents and construction contracts related to the Harbour Club signed from 2023 to present. 2, stay of disbursements, a preliminary injunction enjoining the board from further expenditures of the $6.5 million loan until the court determines if the debt was incurred in violation of the FHPOA bylaws. Declaration of judgment on voting, a ruling that the 50+1 simple majority remains the legal and binding standard for all community-wide votes. Voiding of unauthorized actions, an order declaring any contract signed by FHPOA presidents without a recorded majority vote of the full board to be voided. Meeting mandates, a permanent injunction prohibiting the board from adjourning meetings for the purpose of suppressing resident discourse. Special master appointment, the appointment of a court-supervised special master to oversee FHPOA operations and ensure the integrity of future elections. Yes. Good job, Brenda and Gerry. I like that. All right. Last one, John and Ruth Nesbitt. Last one to date. Okay. I am not sure how many people take the time to write you. The attitude here is that our POA has the power and lawyers to pretty much do what they wish and change the rules to suit their needs. Case in point, a $7 million clubhouse with no vote by an entire community, appointing POA officers internally with no involvement by the community as a whole. There's a lot of background involvement in this lawsuit, and hopefully the guys representing it have provided that. Bottom line for us is that we want a community that is inclusive, that rules and gives us an opportunity to live an affordable life with amenities that we choose, and a POA that includes all the community in excess spending. Their legal representation will weave in legal jargon and say that this was what we have voted on, but it is not. John and Ruth Nesbitt. All right, y'all. I just totally removed myself. Okay, that brings us to date. The one thing I did not review is the 13 pages in this. Nope, I think I removed it altogether. I said it was number 9. I'm going to go ahead and read it because, I mean, we're already at 2 hours and 10 minutes. Why not? You can always, oh, wait, no. I have more letters. That was 17. Hold on. Let me make sure. John and Ruth Nesbitt. Oh my gosh, I can't even believe I said I was done, and I'm not done. Remove this. Let me add the next letter. That was John and Ruth Nesbitt. So here's 17. Nope, that is John and Ruth Nesbitt. Dear Judge Brown, I am a resident of Fairfield Harbour since 2016, and I share the concerns of the property owners. We are fighting to restore fair and proper procedures by the POA, reference Don Ritter et al. Versus Fairfield Harbour Property Owners Association et al. So they're just writing in favor. This is Denise and Joseph Flynn. Last letter. Dear Judge Brown, we are one of the plaintiffs in the above matter. As such, we firmly believe that the board of directors of the POA has misused their positions to the detriment of the property owners and community at large. We also believe that the directors knowingly have disregarded the organization's bylaws and applicable state statutes in furtherance of their own agenda. We believe it allowed to continue the unjust actions of the board will cause irreparable damage to the community and individual property owners. Please help us restore our rights as residents and property owners in Fairfield Harbour. Respectfully, Charles and Janet Craig. So good. Okay, so contrary to I think there were 2, maybe 3 letters sent to the judge that were in favor of the board of directors. Every other letter out of 19 well, that's 17 total letters submitted since January had been in favor of the plaintiffs, right? Getting our community back, having a voice in the actions taken by the community. So the fact that 2 of the letters in support of the board of directors stated that this is not a majority of the community that feels this way, what have you, it's just 32 people. It is not just 32 people. Most of these letters came from people that are not plaintiffs for one reason or another. And that's no shade or judgment thrown. They're just not plaintiffs in this, but do stand with the plaintiffs in what they are asking for. So I just, I know that this judge will be fair and honest and take in all sides. I did find it helpful reading through the opposition to the second amended complaint because it definitely gave some highlights into the perspective of the POA and Hope Carmichael and the guidance that she provided them on why it is none of our fucking business, to be real frank, that they changed the bylaws to where we could never vote anyone off the board. So, I mean, appreciated the additional perspective there. Don't agree, but it was helpful. Let me just add this one thing. I'm going to go back to attachment number 9. Again, it's 13 pages. And while I'm doing that, I'm just going to also give you, if you want the address, to write a letter yourself to the judge. Let me go ahead and say that, and I'll put it in the description afterwards too. Honorable Todd Brown, and it's 832 East E 4th Fourth Street, number 9600, Charlotte, North Carolina, 28202. Okay, so that's who you're going to write to if you want to write the judge a letter regarding this lawsuit. Okay, so let me go back to this. This is the defendant's brief in opposition. Oh, I think I've already read all. This was the thing I read earlier. Yeah, all 13 pages. Okay, so we're not going to read that again, but that gets us up to speed, right? So we filed the second amended complaint in December. In summary, let's summarize. Filed the second amended complaint in December. Obviously, the defendants have opposed that second amended complaint. There have been requests for extensions of time. Those have been granted and or granted in partial. I will show you that for the... I think if we look here, going back to our screen, and we scroll up here, I think the next court date is in March. So it's coming up. So this was signed December. Let's see. Hearings. Upcoming hearing, March 24th, 2025 at the Craven County case. It'll be a motion for preliminary injunction, and it is going to be Carteret County Courthouse, Courtroom Superior 1. So, oh, that's 2025. Hold on. I will find the next court date. It's got to be coming up here. Sorry, apologies for that. I want to say that there's a court date upcoming. I will go back through these other notes from December. I think it was in there where I saw it. Anyway, we'll keep tabs on this, y'all. So, and you're still not even seeing my screen. That's so unfortunate. I'm gonna have to figure that out. But anywho, thank you so much for the time. We will continue to follow this. So we are called up through all the letters submitted to the judge. We have the address if we want to submit a letter ourselves. And we understand kind of the new perspective in the opposition to the plaintiff's amended case from the lawyer's perspective and the POA's perspective. So I hope you have a wonderful rest of your weekend, and we will talk soon. Okay. Thanks, everybody. Bye.